Well, let's get into that with my panel. Jonathan, your colleagues at the Washington Post broke this story. How will this and could this affect the impeachment proceedings?
Well, it'll affect the impeachment proceedings in that it's new information. Remember, one of the contentions during the hearings was that the White House was limiting the release or preventing the release of some emails. It was also the State Department that came up in several of the witnesses who testified. And so what this does is it's just a few more drops in the bucket, or a few more pieces, I should say, in the puzzle of what happened, what was going on. The key thing in the story, Rev, that hasn't been, that Richard didn't talk about in his great report, is that Mulvaney's request, this is quoting directly from the story, Mulvaney's request for information came days after the White House counsel's office learned that there was a whistleblower complaint. And
this
so
came,
what makes
let me make sure we have this right. This came from Mulvaney, the chief of staff, after they were made aware there was a whistleblower.
That is correct. And so what that points out is that the acting chief of staff was trying to find a way to basically backfill explanations for why there was a hold on the aid to Ukraine. And so that's why this is a breaking news story. This is one more piece in the puzzle that goes to evidence that shows that the administration was withholding aid authorized by Congress that was supposed to go to Ukraine, that was being held up because the president was looking for and insisting from the new president, Zelensky, that they open up investigations into so-called corruption. But what we now know that to mean was investigations into the company, the oil and gas company Burisma, and into Vice President Biden and his son Hunter.
Now, when we hear this breaking news, it raises the question, if there were these flurries of emails that started after they were aware there was a whistleblower, it would lead one to believe that they were trying to cover something up, because if, in fact, they had used appropriate or proper procedures, there would be no need for a flurry of emails. Does this look to the public and to the congressional committees that have interrogated people like this is a big deal, because they appear to be operating only because they know, or at least in large part because they know there's a whistleblower and this could become a problem?
Well, good evening, Alan. Happy Thanksgiving. I hate to rain on everyone's parade. I know the reporter, Josh Dawsey, and his colleagues have got great reputations, Carol and Tom. But what this adds is a lethal dose of dullness to an already underwhelming impeachment. When you get into the nitty-gritty of the Congressional Budget Impoundment Act of 1974, you're going to kill the audience. I mean, you're just going to kill us. Already it's turned against impeachment. The Adam Schiff show trial has not succeeded in carrying the day. They've lost ground, 6 points in the Emerson poll, a bigger swing in the Marquette Law School poll. The American people don't like this, and the fact that some people are alleged to have asked the White House lawyers, which is what you're supposed to do, about whether or not what they were doing was legal, that strikes me as interesting to me as a White House counsel alumni. I mean, that's what I used to do, is to make sure we were crossing our T's and dotting our I's back in the Reagan administration. But it doesn't strike me as a headline grabber, and it does, I think, underscore the weakness of the congressional case that we're talking about, the congressional budget impoundment. I get all of the dullness thing and all of that that you claim, but the fact of the matter is, if in fact there was a U.S. Congress vote that gave this country, the nation of Ukraine, who was under military fear from Russia, and they said, we're going to give these $391 million to them, and it was withheld because the President of the United States was trying to extort them to announce an investigation against his potential opponent. And now there is a paper trail that once they found out there was a whistleblower, that they were trying to, in fact, cover how they made the decision about disobeying what the Congress had voted. Dull, you can say all you want. That speaks to a very serious issue, and it questions whether the executive branch can, in effect, neutralize what the legislative branch had voted to do.
You can call it dull, but it is a real issue.
Well, I just got to disagree with you because some of the testimony that I'm sure most of us heard, and Jonathan probably heard, was that impoundments on a temporary basis are not routine, but they are not abnormal. That they happen all the time. That one was in effect in Pakistan, one was in effect in, there were two other countries that came up in the exchange. Frankly, I can't remember anything from this dull set of hearings, but the fact that the Congressional Budget Review Impoundment Act of 1974 is on the table, that tells me they're desperate. I know, Jonathan, you're going to disagree. Democrats are desperate because they did not carry the day in the last 2 weeks.
Well, it seems like, Jonathan, if you feel like if people have flurries of emails, it seems like they were the ones desperate. We're watching desperation. We're not operating in desperation, Jonathan.
Right. Right, Rev, I'm going to speak for those of us who are on Earth One. This is not a show. This has nothing to do with whether the hearings are dull or not. What we're talking about is the rule of law. What we're talking about is a president of the United States who is using his position to not only undermine an ally who is in active war with an enemy of the United States, but also using his position to extort a foreign leader to get that person to open an investigation into a private American citizen, and two, a potential political opponent in the 2020 election. Hugh, I don't care what you're saying. I don't care about the talking points about show trial and dull this and dull that and ratings, whatever. We're talking about the rule of law, the foundation of American democracy, and I am not going to sit here and allow someone to try to tell me and the American people that what they have heard over the last 2 weeks, what they've seen over the last 60 days since the impeachment inquiry was announced, is not what they're seeing. I am believing my eyes, I am believing my ears, and so are millions of other people. And I bet you there are people who are watching right now who are wondering, when will Republicans, when will people who are always talking about how they love the rule of law, love the Constitution, revere the president and the presidency, when will they do those things that they have been lecturing us for decades?
All right, let me bring you back in to respond because I'm going to run out of time. And the point is, you've had decorated members of the military, you had people in intelligence, you had government officials testify, and that's not a show trial. You had credible witnesses, and all of them consistently saying the same thing. How can you dismiss it as a show trial?
Because, and I want to answer you and Jonathan, when and if any evidence of a high crime or a misdemeanor appears, and it's real evidence, not hearsay, I will take it seriously. But I'm not going to take it seriously when I have the transcript in front of me, and I don't consider it to be significant. I actually read the transcript. I followed this very closely. And the histrionics that Adam Schiff practiced, especially in his closing argument, do not carry the day with lawyers. They don't carry the day with Republicans. They don't carry the day with the middle of America.
I brought up the witnesses. I didn't bring up Adam Schiff. I brought up the witnesses. I did not bring up Adam Schiff. And the witnesses' testimony is evidence. But I'm going to have to leave it there. We'll come back with more of Jonathan and you later on.